Hey, everybody. Welcome. We are back, BSBA, the Black Small Business Association. We are back this week with another workshop for small business owners. We are excited today because we have Miss Lauren McDonald with us. She is an attorney local here in Sacramento, and today's workshop is on trademarks, copyrights, intellectual property altogether. So at this time, I am going to turn it over to our speaker and to our presenter. Lauren, it's on you now.
Great. Thank you so much, Dr. Starks, and thank you to the BSBA for inviting me. My name is Lauren McDonald. I am an attorney. I do specialize in intellectual property for small business owners and creatives and artists and things of that nature. There's a lot of crossover. So a little bit about myself, background. I did grow up in Sacramento. When I graduated high school, I went away to college. I went to Los Angeles, and then I went to law school. So overall, I think I've been away about 10 years. And I just moved back in 2018. Well, around 2018, I joined an incubator to help me get the firm started. So that was in Berkeley. And then after a year of that, I relocated the firm here in Sacramento in order to serve all of you lovely business owners and entrepreneurs here. My background is entertainment. That's what my degree is in. So I never had a passion to be, on camera and be talent. I always wanted to be a little bit more behind the camera. And then as my career started to develop, I found I was the more risk-averse person of the group. I was always protective. You hear these horror stories about all of our people, right? All of our artists, people like TLC, they're world famous, world tours, but yet they've signed a crappy contract. And why are they broke? They're bankrupt now, right? Horror stories like that. And I just wanted to come home and serve my people and make sure that that doesn't happen to you. And I was always very intrigued at the thought of intellectual property, right? How do you own something that's sort of intangible? We can't touch it like real property. So I'm going to dive right into the presentation. But first, again, this is new information for some of you. So just first take a moment, take a deep breath in. Okay, take a deep breath out. And if there's something you don't understand, just put your questions in so that Dr. Starks can let me know. I will answer all of your questions. There's no such thing as a dumb question, so don't be shy, okay? All right, so let's get this going. All right, so this is my contact information here at the top. So if you need to reach me, feel free to send an email anytime. This will come to the whole firm, and then we'll filter it out and make sure you get an answer within a few business days. Or if you need to hire me, that's also how you can contact me. So that's just for your information. So, introduction. This matters to small business owners because it has a lot to do with your branding, and if you're investing in logos, very custom designs and things like that, okay? So IP stands for intellectual property, and it's defined as the ownership of the intangible creations of the mind, right? So this covers a wide range of things, from inventions, like if someone comes up with a brand new invention, to things you're probably more used to hearing about, like literary works, books, newspapers, magazines, artistic works. That includes music, and that includes typical art, like on a canvas. Again, symbols, designs, names, and logos, okay? Now, an important thing, please write this down if you don't write anything else down today. There is technically no protection for a raw idea, okay? So in order for any one of these, we've got a few different types of IP we're going to talk about briefly. But in order for you to get the benefits of any one of these types, your idea has to be what they call fixed in a tangible medium, which in layman's terms, we're just going to say it needs to be written down. So as long as it's still an idea in your brain, unfortunately, if you tell someone before you have written it down yourself or designed it or invented it, right? Or built it or recorded it, whatever. If you just tell someone while it's still an idea fresh in your brain, they are free to steal it. And if they steal it before you have it in one of these forms and you've registered it, sorry, you're going to lose out. And if they're successful and they run with it, that's just going to be that. So again, when you're at the idea phase, don't tell anybody. Do not tell anybody unless you really trust them, unless maybe they've signed a non-disclosure agreement, right? One of the most heartbreaking stories I've heard is from an inventor. I think he's local, so I'm not going to say his name, but he came up with an idea for these brand new athletic skull caps. I met him after the fact. He called my office years later, trying to see what he could do because he came up with the idea for these athletic caps. He hired a third-party company to help him build the prototype. They did that. However, he did not file the patent in time. So there is a whole process. We're going to talk about it. But if you have an invention and you want to do a provisional patent, you still have to follow up and file the actual patent by a deadline. And if you don't do that, somebody might steal your idea. And that's exactly what happened. Those people that helped him build it started selling it, and he saw it online that they had been selling it and just kind of ran with it. So again, long story short, if you have an idea, don't tell anyone until you have it solidified into one of these types of IP, right? So there's different types that protect different things. And I have them for you business owners. I have them listed here actually from the cheapest to the most expensive cost to register or set up, right? So depending on what your industry is or what your business type is, I'd say the most common might be somewhere along the lines of a trade secret, trademark, so on. But believe it or not, a copyright is the cheapest to register typically. It's only $60 per, like one-off song, or maybe you have an unpublished artwork, one little thing is only $60 each. Once you start to register multiple or really big things, or if you want to do it really expedited, is when the cost goes up. But just a basic, hey, I just wrote one song and I recorded it and now I want to register it, but I didn't release it yet, $60, all online registration. So a copyright protects original works of authorship. Again, that's pretty much anything that you've authored, right? It's a book, it's a song, it can be a photograph that you took, with a camera. It can be art, anything you've authored, right? It doesn't protect titles. So unfortunately, again, if you just have an idea for a book or a movie and you just have the title, but you haven't really written it down yet, just trying to register the title, that's not going to help you. So again, anything you've actually fully completed and authored. So a copyright, though, is actually a bundle of about 6 separate rights. So once you've registered or you've created something, because we'll learn in a second that protection actually attaches right away. But once you create something and you have a copyright in it, you have these 6 separate rights that only you can exploit as the owner. So let's say I write a brand new song, right? And I record it. But even though, and let's say I release it even, it's my song, right? So I have the right to reproduce it, which means I have the right to, if it was still like 2001, right? I have the right to press up as many copies of CDs as I want to sell, or, whatever that I want to give away. I have the right to distribute it, which is sell it. I have the right to display it. I have the right to make derivative works, which means making a remix or sampling it in a new song that's a little different. And I have the right to perform it for the public. So if anyone does any one of these things to that song without my permission as the copyright owner, that would be infringement. And that goes both ways. If you do one of these things to somebody else's work without their permission, that is also infringement, right? So when you hear copyright, just think in general, nobody else can copy. All right, so when you hear copyright, think nobody else can copy. But thanks to the law, when we say copy, we really mean any one of these things here. Moral rights are a little bit separate and they only apply to certain types of visual works, and it's actually a slightly newer concept of the law. So I'm not going to get into it, but when you get a chance, try to Google moral rights because it tends to be an issue with like street art and graffiti and building owners, and those are the most recent types of cases that have gone to court. All right, so we have one question up. Let me take a look at it really quick. I tried to register a phrase to put it on t-shirts and masks. They rejected my application. Right, a t-shirt, or I'm sorry, a phrase is not an original work of authorship. So a phrase, especially if it's something kind of common, like, you know, just a colloquial phrase we hear every day, like snitches get stitches, something like that. That's not a work of authorship that would qualify. It's got to be something a little more original, right? Maybe like a poem. So what you're describing, and then make sure this also went to the Copyright Office, but also that phrase might be able to be trademarked, but again, that'd be more of a slogan, and you'd have to prove that it's not like generic. It can't be something that everyone's using. It has to be pretty unique for it to be a trademark. So that's, if you have a follow-up question, let me know. But if for the person that tried to copyright the phrase, that's why it was rejected, is because it wasn't original and it wasn't really a work of authorship. All right, so when you create one of these types of works, is the MAGA phrase copyrightable? The MAGA phrase, it's definitely can't be trademarked. I know that. And I would want to say, I don't think it would, it's also not original. It's not a work of authorship. It's just political. A lot of times political things don't qualify for registration. So you'll probably be sad to know that Black Lives Matter also is not, nobody owns Black Lives Matter because it's considered a political phrase. Yeah, unfortunately. So back to copyright though. So copyright protection is actually, it exists, it attaches to the work that you made as soon as you create it. So as soon as you make a movie, as soon as you write a book or you make that song, the fact that you made it, you're welcome, Shirley. The fact that you made it and you're the author, boom, you already have copyright protection. And it's important, I really want you guys to know that copyright is in the federal constitution. So, I mean, think about it. When they came to found this country, that's how big of a deal it was for them to protect their creations, right? It's in the Constitution. So as soon as you create this work, you really don't have to do anything. But if you want to sue anyone in court for infringement, you are going to have that formal registration certificate first, right? So that's that. So again, you don't have to register it if you don't want to, but if it comes to you having to go to court, then you have to show that certificate is step one before you can sue anybody. So you're probably going to wonder about the notice format. Notice is not required. So when I say notice, let me back up. Have you ever seen like a picture or a movie or something, and at the bottom it has a little copyright symbol and it has the year and it has the company's name? That's considered copyright notice. This also is not required. However, if you're a business owner, it is better to be safe than sorry, and it just makes the case a lot stronger when you want to do takedowns and cease and desist, because it's like, hey, you knew you didn't own this, you knew we owned it, and you copied it or you displayed it or whatever without my permission anyway. So the format for notice on anything that you're trying to copyright or give notice about, use the word copyright. Try to only use the symbol if you've actually formally registered. Otherwise, just try to keep it to that. And then you put the year of first publication, and then you put the name of the copyright owner, which can be your business. If your business is a separate legal entity, like an LLC, or even if you just got a DBA, a corporation, what have you, any business can also own a copyright, okay? So If you put this notice on everything, that just helps to, again, it's not required for anything you make after March 1st, 1989, but it just makes a stronger case if you find that somebody's using your work without permission. This is particularly, in my experience, an issue with visual things that kind of go viral on social media, right? Because it's one thing to just share it, but what will happen is sometimes people will take the image and then start using it on t-shirts or backpacks or whatever that they want to use it for. And now they're selling it. Now they're making money. They're distributing it. They're reproducing it. They're doing a derivative work. They're doing all this stuff right here without your permission, and they're making money. So if you put the notice on there, that's a stronger case for, hey, they should know, pump their brakes and not to do that. And then if they do, that's a stronger case for you to get damages. There is a such thing called statutory damages. Sometimes you don't even have to prove exactly how much money you lost. Sometimes there's a statutory minimum amount in there. Boom. You just say, I need that number, run it, because you guys violated. Okay. So that's copyright. If you guys have any questions or if you're still processing, again, just put them in the chat and let me know. But again, there's no particular order also, as far as the law is concerned, there's no particular order of priority. I'm just helping us by going from cheapest to most expensive. All right, so the next thing is trade secrets. Now, trade secrets are a little different. So if you have questions, I totally understand, because this can be a tricky area of law. A trade secret will protect any confidential business information which gives your company a competitive market advantage. All right. So it's a little different, right? It's not a picture. It's not a name. It's just information. But it has to be confidential. It has to be secret. And it has to be such that your company has a market advantage. So some examples are like super top secret customer lists, right? Processes, formulas, things like that. Those are trade secrets. Now, trade secrets are tricky because unlike everything else we have here, they're not in the Constitution, and therefore there's also no government office where you can go register. You can't take your customer list and go say, hey, state of California, this is my trade secret, and register it. And then if someone steals it, you go and sue them. That's not how it happens. This typically comes up as an issue with employees, right? So if you have something that's top secret and it gives you an advantage over your competitors, the way you protect it is making every employee who's going to have access to the information sign a non-disclosure agreement, period. Like, they must do that. Therefore, if they violate it by disclosing your information or using it without your permission, then you can sue them. And there are laws, there are like statutes that say, yes, you can sue people for trade secrets. But again, there's just no registry. So you have to have them sign that in order to trigger that. What else? The issue is also a little tricky because in California, our courts don't enforce non-compete agreements. So again, this is largely an issue with employees. So if there's someone, run a background check, see, do they have a record for embezzling or fraud or whatever? If so, okay, you want to give them a job, but maybe they don't get access to the top secret stuff, at the executive level. So the best way to do this in today's digital age is to have, some cloud software, collaboration software that allows you to block off or do password access for certain folders or certain information that only key people need to have. That's something the court is going to ask you if it does come down to you having to suing someone, because there are defenses. A defense is, well, it wasn't a secret. It wasn't a secret, so it's not a trade secret. It wasn't confidential. Everybody knows how to do this. So you have to be able to demonstrate, no, we protected it, it's proprietary, no one else was doing it this way before we were doing it, stuff like that, okay? So that's trade secrets. And again, if you guys are unclear or you want a little more examples in layman terms, feel free to Google it, and then you can email me after, whatever works for you, okay? So far we've gone over copyrights and trade secrets. Now the next one is actually a license. And a lot of people don't think of license when you hear IP. But similar to a driver license, an IP license is written permission to use or exploit any of these types of IP that are owned by someone else. And all you do is pay them a royalty to use their IP. This happens more than you would probably think. The most, well, I'm dating myself, but there used to be at my law school, there was a profile of a lawyer, of one of our alums, and it was a Black woman. And all she did was actually license. There used to be this, back in the 90s, right? There used to be this fashion brand called Dada. It was pretty popular, like athletic, hip hoppy sportswear. She didn't really own the company. All she did was get a license to use that logo. And she just knew how to market it, and then it blew up after she had got that license. So that's an example. So you don't have to come up with your own idea. If you know someone who has a really cool brand, but maybe they don't have the tools to get it off the ground, or they just don't know how, just get a license. Hey, make a deal with them, put it in writing. Hey, can I license your logo for X amount of years, and every t-shirt I sell, I'm going to give you X% of it. Boom, that's it. That's your license. But it's got to be in writing, and it's got to have more specific terms than that. But that's it. So if you're not super creative, or if you want to expand your brand by just, collaborating with someone else, just get a license. You don't always have to reinvent the wheel. So I hope that helps. And definitely want to hire an attorney to write your license agreement if you do that. All right, so let's get into trademarks, because that's the most popular, or service marks. So a trademark is going to protect your logo or your words that you use in connection with goods or services exchanged in commerce, right? So that just means business. In order to register, it can't be generic. It can't be just descriptive. It has to be it can't be descriptive. It has to be pretty distinct, right? That's because when you turn in your trademark application, they're really going to scrutinize it, because they're giving you what they consider a monopoly over that word or that logo, meaning once you register it and you keep that registration active, you keep renewing it every 5 to 10 years, however long, no one else can use it at the same time as you. That's it, just you. So the whole point of your trademark, your mark, meaning your logo or your little design or your words, is that it tells consumers who made this product or this service. So a good example might be Clorox, right? It's been around for a long time. If you see that diamond with those words in there, Clorox, okay, yeah, they made it. Whether it's a spray, whether it's a gel, powder, whatever, doesn't matter. You see that logo, you know who it came from. What else? Pretty much any logo, right? There's not a lot of copycats out there, because another rule is that it can't be confusingly similar to someone else's. So if you come up with a logo and you intentionally make it look just like Amazon, and you do the same service as Amazon, and then you apply to register, they're going to deny your registration. All right. Oh, and a little bit about fees, because remember, we're going up in price here. So the way the trademark office works is and I believe you guys have already had a discussion of this, so I'm not going to go in detail, but they raised the price recently. So long story short, it used to be only $275 per classification. It can now be as much as $350 if you want to be able to be really specific and put in your own wording, or it can be as low as $250 if you're going to use the pre-selected wording they have in their system. Okay, so that's per class. So clothing is one class, coffee is a separate class, there's all kinds of different classes. So again, that's per class. And if you turn in your application and it gets rejected, they do not refund fees. So you can do this on your own, but it'd be best to have an attorney help you. common law versus an official registration. So a common law trademark is, let's say you launch a new product and you have a cool logo and you just start using it. And that's fine. Nobody else, as long as nobody else is using it, that's fine. Because if you're the first person to use it in commerce, so that means like out in the open, published, out, it's not a secret, it's not exclusive, out in commerce, then you're going to have a common law right to that mark. However, if someone does sneak in and register it before you, you might lose out because there's a very narrow window where you can oppose somebody else's mark if you feel like they are using the same thing as you. So if you miss that, then unfortunately you'll lose out. You can also register at the state level. So in my practice, we've been registering a lot of the cannabis companies at the state level because cannabis is not legal yet, but it's legal by state. So you can have a state trademark. Every state's Secretary of State office will do trademarks registration, or their business division, whatever they have. However, it only protects you in that state. So again, in this digital age, that doesn't really help if you have like a really big presence, you're online and you're nationwide. But it's better than nothing because, again, when you turn in your trademark, you should be doing a thorough search ahead of time. And there are softwares out there that will search every state's database. So again, it's better than nothing, but the best is to get the official USPTO registration. Okay. I don't know if you guys can see it. It's kind of small here, but I wanted to tell you a little bit too about using these symbols. Okay. So another way to help protect your common law mark. So again, let's say you just launched your business. So you're kind of just testing it out, right? You're only in month 1, 2, 3. You're not sure if you're going to stick with this or if you have to pivot, or maybe you're not selling anything at all. But just to be safe, you want to let people know, hey, I'm serious and I'm using this mark for business and I don't want anybody else to use it. You can use this, the TM, or if it's a service, you use the SM symbol, that little one up there. You can put that right next to your logo or your phrase or whatever it is you're intending to use as a trademark. So you use those if you're not officially registered yet, but you want to let everybody know I'm serious about this being my trademark and registration's probably coming. Okay. So again, you use the little TM for your trademark before you register, and you use the little SM before you register, versus you use the R inside of the circle after you're already officially registered. Not applied, but officially applied. They examined it, they approved it, and you're registered. Okay. Okay. So really quick, we're going to talk about patents. Patents, I don't do patents because they're very complex. They require a very, very technical background, meaning expert in like math, science, engineering, things like that, because this is what applies to inventors. So all you inventors out there, listen up. A patent is the right for an inventor to exclude all the others from making, selling, or using his or her invention for a certain period of time. And in the US, again, patents are in the Constitution. So in the US, there's 3 different kinds. You can have a design patent, you can have a utility patent, or you can have a plant patent. And plant is exactly what it sounds like. You discover or come up with a new plant, you can get a patent. They don't tend to do it for a genetic modification, more so straight up horticulture. But utility is going to be anything functional, kind of like a tool, or also, I believe, medication. For medication, for all my Sacramento allergy sufferers out there, right? I don't know if you remember, about 2 decades ago, Claritin used to be available by prescription only. That's because they had a patent for that drug. Fast forward today, it's over the counter and there are generics because the patent has expired and now everyone's free to copy exactly what you just did. So again, that's that definition there, certain period of time. Not all patents are the same amount of length, but I believe on average they're about 10, 20, 15 years, about that time. Another example, I think whoever's the guy who invented like the water gun or the super soaker was an engineer. I believe he had a patent on that. So patents are the most expensive. I don't know. I don't even know how much those fees are, but I know it takes a lot of money to get a patent going. I believe that Shark Tank lady, forgot her name, but the one with the long blonde hair, she owns a lot of patents. So again, if you're wanting more information about patents, you can go on my website. There's a resources page, and you can click the United States Patent and Trademark Office actually has a ton. I just got an email today about new resource programs for inventors. You know, if you can't afford an attorney, they'll help you find one and get it going. So those are the basics. That's intellectual property, and that's the way you basically make something out of nothing, right? So I want to talk a little bit about, as a business owner, once you actually have registered or you've established one of these things, now you're in charge of enforcing it. So unfortunately, in America, we don't have any like copyright police. We don't have trademark police, right? Nobody's going around to all your businesses or even really scouring the web to make sure nobody's copying your stuff. It's on you to do that, right? So let's say you have a valid copyright or you have a valid trademark. You find out somebody's straight up impersonating you, or they're just using it without your permission. You then, either yourself or your attorney, has to send them a takedown notice. I do this as well a lot in my practice, particularly in social media. It can be an issue. So all social media platforms usually have a pretty straightforward process of reporting infringement. And then you tell them why, and then they look at it and they usually take it down within a day or two. But the other side does have the right to respond and say, no, I think it's a mistake, or no, I do have a license, or whatever, right? So I just say all that to say it can get a little costly. It can get a little costly if you've got like a really big popular brand that everybody wants to copy. Another example is the Kamala Harris T-shirts. I do represent Gordon, the guy who came up with that design for the shadow of Ruby walking behind Kamala. We registered that, but there are a ton of copycats on the internet that I was flagging almost every day for the first couple months there. So again, it's tough because you've got to do it on your own. If you've got physical goods and you've got like a high volume of stuff that gets imported, customs, you know, like United States Custom and Border Patrol, they have some registration stuff. So they will try to help you with counterfeits and taking fakes out. But for the most part, it is on you. Another thing too, and this goes the other way. So let's say you have a business and you're like, oh, I want to use the Louis Vuitton logo or something like that. And if it starts getting really famous and they want to come after you, they can do that. Another example is Tiger King. I don't know if everybody remembers last year, Tiger King was like trending for a couple months last summer. That's what bankrupted him. It wasn't the going to jail for the murder threat. It was because he took Carol Baskin's Big Cat Rescue logo, copied it. He might have only changed one word. I think he added entertainment at the end, and he put it on his website and was trash talking her and like diverting funds and just whatever. So she filed the lawsuit for that, and he lost that. So that's why he's now bankrupt and she owns his farm, is because when you're copying a business that makes millions and millions or billions of dollars every year, and they can prove, you know, that's what infringement is. Hey, you're making me lose out on money. And if they go to court, then you lose because you were copying, but you thought it was cool because it was popular. They're going to get a judgment, and you're probably going to lose. So if you guys have any more questions, feel free to share. But the main thing I want to emphasize is always, always, always do a thorough search before you invest in your branding for your company. So if you have a logo idea, if you have logos, any sort of mark, any sort of design, right? You want to do a thorough search, not just the internet, but like look up business registries. And now, again, in this digital age, try to look overseas even, because all of these things we just talked about, well, not all of them, but for sure, trademarks, service marks, you can register those in a separate country. So you can register here, you can register in a lot of other European, African, whatever, a lot of different countries, right? So it's very possible that you can come up with an idea over here in Sacramento and somebody else in another part of the country or in the other part of the world has the same idea and you guys sell similar or the same things, right? So just do a thorough search before you invest heavily in this is my logo, and then you've got your website branded, you spend money on business cards, and you've got it on the side of, a company fleet of vehicles, right? All of that is going to be expensive to redo if a month in you find out, oh, this person actually has something very similar or they're already using it and they started using it like a month before me. Those kinds of things happen. That happens. I actually have a client. She came up with like a trivia card game called Blackout because it was all about Black culture. So in the trademark office, that's, however, a card game is only one classification. We turn in her application. Come to find out, barely by like a couple days, someone applied to register Blackout also for a card game, but theirs was a drinking game, but still too similar there. So it happens. Don't think it never happens, because it definitely happens. I could talk about fair use, but without your guys' questions, I don't know if we should. But that's a really common thing, is because most people will go, as far as copyright goes, they'll go, oh, but what about fair use? Fair use means, yes, you use somebody else's work, but only a little bit. Keep in mind that fair use is a defense. Okay, I'm gonna say it again. Fair use is a defense. So that means if you've copied somebody else's work and you're trying to say fair use, that means they've filed the complaint already. They filed the complaint for damages. That's going to go to federal court. Now you got to get an attorney and answer. All of that costs money. So again, don't rely on like things you might hear in a chat group or stuff like that, because sometimes it's not always legally accurate. Let me back up a little bit too. Copyright, what we talked about for notice, that also helps because there's this concept of public domain. So any work that's in the public domain cannot be copywritten. That means anybody can use it. If it's in the public domain, anybody can use it, and you're not infringing anybody's rights. But public domain is not the same as just like it's on the internet, right? So if you Google search something and it pops up, that's not the public domain. Public domain means either it was made so long ago that the copyright has expired, the protection. So now, if you make anything today, your copyright is valid for the life of the author plus 75 years later. So the life of the author plus 75 years after, right? So when I say something old, I mean something like really old, like Shakespeare, that kind of stuff is in the public domain now. So you want to be careful of that. But that's what the notice helps with, is so that people can't try to say, oh, I didn't know, or it looks kind of old, or wasn't sure, right? No, put the notice on there, period, bottom line, you copied it. I don't have much left. I tried to leave room for questions throughout or at the end. So you guys let me know if there's anything else you want to talk about, something you want to clarify, something you heard. I'm going to put the contact info back up here at the top. But other than that, that's it. That's IP in a nutshell. Again, this is really important for branding and growing your business because you want to make sure your business stands out from others. So first do your search. Okay, nobody's got the same thing as me registered. Mine is unique. It's distinct. Okay, and then test it out maybe, and then you can register. All right. And if you want more resources, again, you can go to, let me type it up here, USPTO website or my website, which is on the screen. And they've got a ton of resources for inventors. But again, feel free to email me if anything is unclear or it's not making sense or doesn't add up with something you previously heard. I also do free 15-minute consultations for new clients only. So if you have an idea or a question a few days from now, a few weeks from now, you can always hit us up then as well. Well, I hope this was helpful, and I would be excited to hear more about you guys' businesses. Keep in touch. Luminite Law is also on Facebook, so follow us, leave a comment, tag your business so I can follow you guys and learn more about the local businesses, and I'd be happy to come and visit and patronize you guys. Yeah, that's about it.
Thank you so much, Lauren. This was such a great webinar. It was so informative. A lot of great information for our business owners. We just want to say thank you from BSBA. Also, everyone in our community, we want you to share this information, share this video with someone you may know, with a friend or a family member, some great information to really help our community and help our businesses and even help people individually. Also, follow Lauren's page at Luminite Law, and I'll put her contact information back up here with the spelling of it. She is on Facebook, like she said, at Luminite Law, and you can go in there and like the Facebook page. Contact her with any questions that you may have regarding these subjects or others. And again, thank you. There's no questions in the chat. You answered what did come in, so it was very, very thorough. Very thorough. Yes.
I hope everyone did fall asleep, but hopefully I'm just explaining it better and better every time.
Yeah, it was very, very good. So again, we thank you for joining us and partnering with us today to present this for us on behalf of the small business owners. So thank you so much. And we want to give everybody back their day. Thank you all for joining us. Again, go and like the BSBA page, the Black Small Business Association of California. Go and like Luminite Law as well. Share this information, contact Lauren, tag your businesses on her page. Let her know who you guys are out there and how she can help, how her service might be able to help. If nothing else, we're going to give you back your Monday. Good night, everyone.